Hi, I'm Debbie Moraes. Welcome to Legal Matters, the program that's been designed to address the critical and sometimes contentious issues that are facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. We want to begin, of course, by thanking the legal counsel and sponsors of this program, which is the Bazar law firm in East Providence, and today we have with us just and only David Bazar. Welcome. So today we're going to be covering a smorgasbord of summer fun topics. Innocent, simple, fun for some things, some little annoyances, and some things that turn out to be downright hurtful. We have a few topics that might be touching the gray areas of perhaps hospitality, family law, maybe even tort law. David will get into that. You'll have help if your kids are injured in sports, or if your kids are traveling alone, or they're video gamers and perhaps exposed to either predators or even inappropriate content. Maybe we'll talk a little bit about the adults who might be exposed by wearing spray paint rather than a bikini. So let's get into it. First off, is it legal to wear nothing but body paint in public?
It depends. So as you know, back in the day, there was nude bathing at Moonstone Beach, for example. Our own Moonstone Beach. And the issue there wasn't the nudity, but the proximity to homes and piping plovers, more importantly.
Pity the plovers.
Yes, so the plovers won, the nude bathers lost, and that was out. But it wasn't because there was an ordinance or some other rule against it, and there are rules in different areas and ordinances that prohibit nudity for certain reasons, and certainly public mores and morals will rule the day on a lot of that.
It's funny because I guess whether we talk about summer's heat that makes someone do it or Halloween gags, I guess many have wondered about that because a couple of years ago even, I think it was American Eagle had a campaign where they were saying, here are your tightest jeans ever. So it was sprayed on jeans to make it look like they were actual jeans, but it actually was nothing more than paint. Would a bikini have covered more? I'm not necessarily sure. But why has have different states avoided or been so vague about what's considered or what's nudity?
Well, again, there's a couple of different things that come to play there. Different states have different rules on what you cannot do in public. And then it gets almost to that definition of pornography where one of the Supreme Court justices says, I know it when I see it. So different states have different rules and different takes on what's acceptable and not acceptable, and that would fall into that same category.
Seems to me, though, that with the way some fashion is set up these days, those panties and pasties are probably even more revealing than a very good paint job. Mm-hmm. Some of them anyway.
Right. And so we're not talking about car restorations, but a frame-off restoration on your body that is not appropriate, even though it looks appropriate, depends, again, on where you are and what the circumstances are.
So if someone were thinking about it, would you just say, just don't do it, not even the body paint, don't even get into it, just bring a towel or something?
Right. Well, it reminds me of the case, I believe, of a woman who might have been selling condoms or something in what was one time a photo booth drive-through thing, and there was an issue as to what she was or was not wearing. And again, it depends on the place, the time and the place. There are rules for strip clubs, there are rules for people doing business, and there are rules for people going to the beach, and those rules may vary. So common sense might be your best guide.
So if there are rules about what's considered the public place, I mean, some of those strip joints are public places, and they get away with a lot more or a lot less, I guess, than others. But there isn't a single place someone could actually look and have a checklist of where you can and can't, I guess, anymore. Moonstone is off limits.
Well, again, there are towns that regulate what you can do in public. There's ordinances in different cities and towns about swearing, spitting, and chewing gum, even. So all of those things can vary not only from state to state, but from town to town and from place to place. It depends, there might be different rules for a strip club than there are for walking down Main Street.
Got it. So let's segue from adult games to kids' games. Kids often are involved with sports throughout the year, but say for the sake of argument, particularly in the summer, they're playing baseball, they're playing whatever they're playing. Whenever anybody engages in some sort of sports, there's inherent risk. There's no question that every athlete who votes to play hockey accepts risk to some extent. What happens, some of these injuries could be minor, but what happens if you have your child or a child who's involved in a game and you happen to be the parent, the witness that sees an injury that seemed not to be so accidental? Some boy on the opposing team wants to take your son out and just throws the wild, reckless pitch, not once but repeatedly. Is that innocent? Apparently not. What do you do about it? Is it a legal issue, and especially if the child is hurt?
So there are rules on the playground in recreational sports and organized sports, and there are certain things that are inherent dangers in any game. Soccer, when you head the ball, there's a risk of concussion. Football, obviously, we know the risk of concussion there. Hockey, again. Now, what you're suggesting is those times or occasion where someone may step over the line and do it intentionally. And if it's provable, if it's something that's so outside the four corners of the rules of the sport, there can be, and there have been cases where torts have been brought, civil actions for civil wrongs, meaning an intentional assault. Or negligence is harder in a sporting activity because it's foreseeable that someone could negligently check you into the boards and injure you. But if someone takes their stick and hits you over the head in a hockey game and does so, as you said, repeatedly, obviously that goes beyond what's foreseeable and expected in a sport.
So might someone who had an injured child then say, oops, I didn't know it was actually that pitch was going to happen, and I didn't take a photo of it. It was a moment in time and I can't repeat it. But how do you build a case of that? Would you have to ask every parent on the field, hoping that you remembered who the parents were, ask the coach? Would this end up being a protracted, long, drawn-out thing to try to prove that this child was deliberately trying to hurt another?
Right. And if it's a close call, you probably don't have a case. But if there are people there and there's a serious injury and they can tell you, people will come and say, that wasn't accidental, that was intentional. You'll know who was there, you know who the rosters are for each team, you know who comes to watch those kids play. You'll have your witnesses to prove your case. But there are other negligent things that can come up, and then sometimes you wonder whether or not those are actionable. For example, if you play a sport where there's certain equipment that's always used, and now your children are at a camp or at a league where they're not using the protective equipment, and you say, but this is what they do in other places, there may be a suit against the camp or the league or whoever's sponsoring that activity if they don't use, and this is where the negligence case could come, equipment that's typically used to protect children. For example, if it's baseball and you wear those helmets when you're batting, and in this league they say, oh, we don't use those helmets. Well, you can tell them that's not how it is, and you can choose not to participate for your child if you want, but it's hard to put the onus on the child to be the only one wearing the helmet when everyone else isn't. And if the child gets injured, I think there could be a negligence claim against the organizers. If
the boy said, well, Mommy already bought me a helmet and this one's just fine, then the league has to say, this is what's sanctioned, yours isn't. You're either in and wearing this or you're out and not playing. Is that how it has to come down?
Well, in that instance, if the league has a helmet and the helmet is, in their opinion, better than the one you brought, then they would be justified to say you have to use ours. But if yours is better and you're injured using theirs, then I think there may be a claim for negligence for saying, no, your equipment wasn't up to the state of the art that I could have used and I should have been allowed to use, and since you didn't let me, you're negligent in putting me in a situation where I would be injured.
Okay, let's continue on that with the kids and the equipment. Most equipment in some way has to be maintained. Suppose you're at the gym or you're using some piece of equipment and it fails, it breaks, you fall off the treadmill, the belt moved, it went too fast, whatever it was, and it had been working, but you think that it wasn't your being a klutz necessarily, or that you were inebriated while playing or some such that put the onus on you, but you think it's the league's responsibility for a defective product or the gym's responsibility for a failing product or not being maintained. How do you prove it? What do you do?
So I had a case once where a fellow came to Rhode Island and was staying at a hotel that had a workout area, gym, if you will. And they had some equipment made by a well-known equipment maker for workout things, very similar to products he used in other states. This one didn't have a pin that you could put in to set it so that it would stop the bar from coming down on you. But he thought, well, this is a well-known piece of equipment. I'm sure that it must have something internal. And he thought it was bolted to the floor as well. So he started working out with it, and lo and behold, he slips, the equipment moves a little bit, and the bar comes down and breaks his neck. So there was a lawsuit that we had against both the hotel and the maker of the equipment because the equipment did not have a safety pin in it internally that would have stopped the bar from coming down, and the hotel that managed the equipment didn't bolt the equipment to the floor, and they could have. And if it didn't slip, he wouldn't have lost his balance, the machine wouldn't have come down on him. So he was able to recover against both of them as joint tortfeasors for his injury.
What about whether it's kids at school or even this case that you're citing, when you use someone's gym or when your children are participating in school or league sports, I think most parents, most people have a waiver that they need to sign. And I assume that that just absolves the originating party of some risk and keeps them somewhat immune, but is it just the point of something being defective that means that waiver doesn't apply?
So my feeling on those waivers is they're what I would call an adhesion contract, which is a one-way agreement. You don't get to negotiate the terms of those agreements, the terms that are in it. And so therefore, I find that if they're enforceable, they're very limited. So if there was some negligence that is foreseeable and part of the everyday activity of whatever you're signing up for, they may protect against that. But if there's something that's above and beyond the normal foreseeable negligence, for example, they're using defective equipment, or they're not using equipment, I don't think that that adhesion contract, that release, is going to release them for something that you didn't know at the time you signed it was a possible risk.
I imagine that part of that thinking would be, how could you possibly know that they hadn't oiled the machine or they hadn't changed the belt or tuned up the whatever?
Right.
And if they didn't and it wasn't maintained or if there was something defective, then you have both the hotel, as you were saying, in one case, plus the manufacturer.
Right. And certainly that agreement, if it's signed to release the hotel, for example, when you sign in, and there may have been one in that case, where you signed in saying, you know, I relieve you of any negligence. Well, yeah, if I slipped on the floor and they, you know, may or may not have had notice that there was some wet towel on the floor or something, maybe that adhesion contract, which is called a release in their parlance, stands up. But for the most part, I don't think, unless you have the ability to sit and negotiate the terms of what you're releasing, that it's 100% effective against every injury.
Okay. And one other issue. Often you'll hear adults screaming and yelling at coaches. Well, sometimes coaches do cross the line. Most of them, well, many can be very difficult, tough, hard-nosed, but okay and healthy and safe. How about if you feel that the coach is above and beyond and really not working in the best interest of your child? I don't know, he has them working out one too many hours in the 102-degree heat, or, you know, some of those excesses, doesn't give them water, will make you shape up. Do you have any recourse legally, or how does that work?
There have been cases where there are excessive workouts and someone unfortunately is seriously injured or dies and they sue. And I think there have been some success on that level. So for that reason, colleges that have their preseason workouts and high schools that have those preseason workouts have really tended to be much more careful with not allowing the athlete to get a drink during the workout or whatever. They're better about that. But There is recourse. Of course, one of the things you can do is take your child out of the activity. Now, I know that's not what you want to hear or what you necessarily want to do, but you don't want to expose your child to that danger, and if the coach isn't going to be reasonable, and you go to the supervisor or whoever there might be, if it's a high school, the athletic director, and you're making it worse on your child because now there's some retribution, I would take my child out of the activity.
And that would be a reasonable parent, never mind a lawyer who's just behaving as lawyers
Because
would.
at that point in time, there isn't damages, so there's nothing to sue for. And if you can prevent the damages, and I know it's not an easy answer because if you have a child who played football in youth leagues growing up and wants to play for the high school team, or if it's another youth league team that they want to play for, you want to allow them to do that. Now, there are some other options. If it's a youth league and there are more than one team, you might be able to get them to let your child go to a different team. But it's not a lawsuit until there are damages, and you want to try to avoid the damages.
But if there are, then would you lose a case based on the fact that you could have pulled your child and you decided not to? Is that reason to lose a case?
It's a possibility that it's a reason. They may say that you've assumed the risk by keeping your child in that activity. My argument would be, well, was there an alternative other than taking them out totally? Could I put them on another team? Did I try to do that? Have I taken steps to do that? It's assumption of the risk. If you know it's icy on the stairs that you want to walk up to get into that store, and you know, or let's see even better, you're in the store and you need to get out and there's been some accumulation, and it's the only way out, then if you don't have an alternative, it really, even though it can be dangerous and you know it can be dangerous, if there's no alternative, I don't think assumption of the risk applies. Now, if you could have gone out the back stairs that have been cleared and you chose to go out the front, then I think you could argue that you assumed the risk. So to compare that to the child who's in that activity, if there's no alternative other than yes or no, in or out, I don't think assumption of the risk necessarily applies, because what would a reasonable person do? Take the kid out altogether, or try to make accommodations and get changes made? And if you fail at that and something happens, maybe you can say, well, look, this is what I've tried to do, and I was reasonable.
Good advice. Okay, more about children in a different setting. Children of, say, divorced parents. There are many children who might be flying to see the parent, the grandparent, and they are the UMs, the unaccompanied minors. What are the laws, or what kinds of things do we need to be aware of when a child is being put on a plane and expected to be picked up on the other side? Where is the airlines do assume some responsibility. I understand they can even pay fees for that. I don't know whether or not they should. I think that they should be able to take care of a child without charging more, but nevertheless. So if you are a parent and if you are a lawyer, you're a parent, what do you do to protect your child? If you're a lawyer and someone doesn't do what they're supposed to do at the airline level or whatever, who's responsible? How do you take care of this?
So, as you said, there is a service, and I have seen young unaccompanied minors traveling to probably visit another parent, and I see the airline representative walking them on the plane, explaining to them what the next leg is, if there's another leg, and the stewardesses and whoever else, making sure that they get off at the right spot. I do think that if there's some mishap that happens and it's the airline's fault, there can be negligence and liability on their part. So if you're, as a parent, taking reasonable steps to make sure your child's able to travel to where the child needs to go, even if there's a bit of a fee, it's probably less money than having to pay for you to fly out with the child and then fly back and then fly out again to get the child and come back. There will be some responsibility on the airline's part if they assume the responsibility of making sure the child gets to where the child's supposed to go.
So many kids have to do that. Do you think that the airlines are generally responsible and able to work with whoever's the booking agent, the parent or aunt or grandmother or whatever, so that they can work out in advance for normal provisions? I mean, assuming that the child doesn't suddenly have a seizure on the plane, and I don't know how that all works out, but there are usually steps in place that the airlines will take. Does the child know his or her name? Do they know grandma's name and all the rest? I think that they should reasonably be able to expect that the child can at least communicate if he's traveling alone. And if they can't, I guess they have to do something else. But only at that point, if they can take care of themselves to say, here's who I'm going to see, here's my little name tag. What other things do you think that parents need to do to make sure that there aren't glitches along the way? So, for example, you mentioned a leg. There's a layover. You'd hope that it could be a smooth flight, but suppose the kid has to change planes, deplane, all of these kinds of... Is that something that the child has to be aware of, or is that something that you just assume that the airline will just come up to that child and take care of rearranging every aspect of the flight, including cluing in grandma on the other side of the leg?
So as a parent, there's a couple of things. First of all, you're not going to let a child that's not old enough to speak and understand where they're going and who they're seeing and who's picking them up travel alone. You wouldn't send an infant in an infant seat to the airline and say, please ship my infant to the dad in some other state, because there's too many inherent dangers in that. The second thing as a parent is you would want to make sure that whatever airline it is has a process that they follow and that they've done this before, and most airlines have, so that if there are legs, who walks the child from one plane to the next gate to make sure the child gets on there, what procedures are in place when the child arrives at the final destination to make sure that the person picking up the child is the correct parent. And I have been on planes where this has happened, and I've watched it, and the airline had someone take the child off the plane after both legs, and I was on both legs with that child, and then the father had his ID out and paperwork to show, yep, I'm the dad, and I can prove not only am I supposed to have him, but this is me. And I watched them follow that through, and you'd want to make sure that an airline has that process in place.
I know I've read in doing some of this preparation that some airlines are so cautious of this that they don't even want to take responsibility if there is an evening flight that might, for example, if there were bad weather or some problem with that would allow or require that they have the child overnight. They just don't want that culpability. But even at that, suppose you can't anticipate that. Is an airline supposed to be responsible for a child for an overnight if that's what it comes to, for some unforeseen, what do they call it, act of nature that exonerates them from booking you in a hotel? You'd have to take care of it yourself. A child can't, clearly.
It's not a plane's mechanical failure, so they're not going to give you the voucher to stay in that Fleabag hotel in Atlanta. But if it's an act of God, they don't have to do that, and it differs, though, when they have your child in their care.
Yes.
And so they have responsibility to make sure that child is taken care of and is someplace safe, and that there's somebody with that child all the time. So I can understand them not wanting to take the responsibility if there's a layover or a possibility of missing the only connection to the final destination, and therefore they'd be responsible for that night. So I wouldn't blame the airline if that's what they wanted to do and that was their policy.
Let's say that you, as the parent, have done what you needed to do to make sure that the airline is in place, they have a protocol, and it meets your standards. It's acceptable. But suppose somewhere they do fail. What happens? Is it a civil suit if they don't live up to their end of the bargain after you might have even paid for that UM status, unaccompanied minor status? What happens?
Yeah, so if there's damages as a result of that, there could be a suit, and to me, it's a breach of contract. There may be airline regulations that also apply. I've had cases where somebody got injured in a flight, and there's the Montreal Convention, it used to be the Hague Convention, I think it's Montreal Convention, that covers international flight. It was a flight to Canada. And there are different rules that apply to injuries on flight and where it happens. If you're at the airport, if you're at Green Airport and you're in Rhode Island, does Rhode Island law apply, or does the federal law on aviation safety apply? And, you know, it really depends. Have you deplaned? Are you in the terminal? Are you still on the plane? Are you in that little gateway or whatever they call it that goes to the plane? There are a whole bunch of different rules that apply. And I'm not 100% sure if there are rules that apply to the unaccompanied minor situation that cover that, but I am pretty confident that at a minimum there would be a breach of contract or a negligence claim if they did something wrong.
So the first thing, when you obviously go to the airline first, but if you don't have maybe it's a matter of, we'll give you a free airline ticket because there wasn't that much damage, that's one thing. But if they really think that there's some harm, they might actually have a suit that you have to investigate with all of those different guidelines and places that they might have been and the rules that apply. That's very tricky. Good to know that there are that many nuances. How about a different thing? So your child is an artist, or thinks he is. So he decides that he's going to spray paint under the underpass of Route 95. He's not really defacing property if he's an artist, is he?
Yes. There are, I would say, anti-graffiti laws, and even if your graffiti in your eye, the eye of the beholder, happens to be really nice artwork, you can't do that. And if I were a judge and that child came in front of me, he would be cleaning paint off underpasses or bridges for a long time.
Whether you are considered to be Van Gogh or vandals, apparently there was a well-known Banksy, I think his name is, but he's been notorious for putting together some beautiful murals, which on the given market he's making thousands of dollars. The question is if he's really did he actually do a service? He didn't really get permission, that makes it illegal. He didn't do anything terrible, which means he was defacing property, but someone might say that it was because I wanted that concrete to stay gray instead of a wonderful mural. Is there a way that you can say across the board, across the nation, everyone is against this graffiti?
You can't deface other people's property without permission of the owner. And even if it's not defacing it in your opinion because it's Van Gogh, as opposed, as you say, to being a vandal, you can't do that. Now, if you are Van Gogh and you get the permission of the owner to do it, you perhaps could even get paid to do that. But you're not going to be able to get out of the penalty by saying, well, look how beautiful what I did is.
Apparently in New York, the NYPD decided not to try to chase him down because they weren't successful and it was getting to be too costly, but nevertheless they were trying, as you were saying, to discourage that because no one asked permission, whether it was for the state or whether it was even private property, so it's not a good thing. So children, keep your chalk on the street rather than spray paint on the overpasses.
Hopscotch on the sidewalk in the summer, probably you can get away with that. Probably
not a problem. So children love to play games with the little bit of time that we have left. If children are gaming and they are signing up for these apps and downloadable things that are free, what do you say to parents? Yes, they should always watch what's going on, but what happens with the fact that the apps are often capturing the children's private information, and it's not legal in some ways, but really sometimes a parent wouldn't know. What do you suggest? What's the story about that?
It's really going back to the same discussion we've had about computer use and all of those other things that put you out in the public domain. So, as you said, mobile apps oftentimes send information back to the person who provided it, location, what you're doing, what you like, those kinds of things. You need to monitor what your children are doing very carefully and know exactly what the app is that they're using and how it works.
Good to know. And I guess we have to we should have a talk too about what the providers have as laws for them to protect them as well. We hope that these discussions about kids and body pains and nudity have been helpful and hopefully fun. We wish you a fun summer and a safe summer. Thanks, David. Stay tuned to Legal Matters. Our discussion of legal matters continues. Join us.